Welcome to class 11 of Secretarial practice. In previous class, we were discussing about the stages for forming a company, and already we have discussed promotion stage. So, in promotion stage, we have studied the steps in the promotion stage also. So, today we are going to proceed with duties of secretary in relation to promotion stage. So the first is to assist in investigation. So we are going to deal with the secretarial duties, right? So who is the secretary in the promotion stage? Normally the pro tem secretary. So to whom is going to assist now? So he is going to assist to the promoter. So he helps the promoter in making the detailed investigation regarding the proposed plan or proposed venture. So what type of investigation? So he is going to investigate or find out the financial possibilities, commercial possibilities, technical possibilities. So in making such investigation, the pro tem secretary is going to help the promoter. Then the next is assist in preparing financial plan. So your financial plan for the proposed venture should be prepared, and the promoter is going to prepare it. Who is going to help? The pro tem secretary is going to help. So what kind of financial plan? So the financial plan, like how much you are going to acquire, from where you are going to acquire, how much you can invest as a own, or how much you are going to acquire as a share capital, or how you are going to allocate that capital. So how much you are going to keep it as a fixed, how much you are going to keep it as a working capital. So all this financial plan the promoter is going to make, and the pro tem secretary is going to help the promoter. The next is arrange meeting. So normally when there are more than one promoters will be there. So they have separate ideas, right? So in order to discuss regarding the proposed venture, so how to proceed with that. So regarding that, the meeting will be, or meeting should be held, and to make such meeting or to hold such meeting, so necessary arrangement should be done, and as a secretary, the pro tem secretary is going to arrange for the meeting of promoters. The next is to attend meeting. So as a secretary, he is going to attend the meeting of such promoters, and is going to record the proceedings of the meeting. The next is to help to finalize preliminary contract. So what is this preliminary contract? So preliminary contract is nothing but the primary contract, we can say the first contract. So here the contract which is, or the contract which you are going to enter into before incorporation of the company, we call it as preliminary contract. So this preliminary contract is not enforceable. Why it is not enforceable? Company has not come into existence, so the company cannot ratify it, right? So we can say it is not enforceable unless the fresh contract is been prepared with the same terms and condition after the existence of the company. So preliminary contract means the promoter will enter into the contract with the third party. So the contract, like, so making an arrangement for advertisement, making an arrangement for the promotion of companies, all these things. So to finalize this preliminary contract, the pro tem secretary is going to help the promoter. The next is help in drafting memorandum and articles of association. So here we are going to draft the memorandum of association. So the memorandum of association is the first document, we can say. So this document is prepared by the promoters. So the promoters are going to prepare the memorandum of association. So what does it carry? So this memorandum of association will have the information regarding the name of company, aims and objectives, etc. And the articles of association, like, so the documents which contains the rules and regulation regarding your internal management of the company. So these we call it as articles of association. So here the secretary will help the promoter in preparing or drafting such memorandum of a memorandum of association and articles of association. The next is print memorandum of articles. So you have drafted it, kept it ready, so now it is your duty to print it, right? So the promoter is going to print all these memorandum and articles, and being a secretary you should make an arrangement for that. The next is you are going to obtain the approval of the proposed name from the registrar of the company. So here in this point we can understand you should have name for your company, right? So you are going to propose or plan a name, so which we call a proposed name. So for your company you are going to plan a name, and that name should not be similar to the other company. So what happens now when it is not, if it, or we can say it should not be similar to another company. So for that you should get an approval from the registrar of the company. So the next is keep documents ready to file with the registrar. So what kind of documents? So first is the written consent of the directors. So written consent of director is nothing but, so directors should show their willingness in writing, so that I am ready to be the director, and to be the director should purchase the qualification shares. So the next is notice of address of registered office of the company. So notice of the address of the registered office of the company. So this is the document which the secretary should keep it ready to file it with the registrar. And the next is statutory declaration. So your statutory declaration is nothing but all the legal requirements of the act, or act means here according to the Companies Act, what are the legal requirements? So to bring the company into incorporation, so all the statutory declaration or statutory legal requirements should be kept ready, and we can say statutory declaration that what all are the legal requirements which is been prescribed by the act. So such requirements is been agreed with. So this is the statutory declaration. So here we are going to complete the promotion stage. So the next stage is our incorporation stage. So incorporation stage is nothing but, in this stage the promoter proceeds to get the company registered. So soon after the promotion stage, the promoter is going to proceed to get the company registered. So for that what they are going to do? They are going to apply for the registrar to get their name reserved. So in the first stage you are going to have the proposed name, right? You are going to have the proposed name for the company, and you should get the approval. And in this stage you are going to get the approval, which means you are going to apply for the registrar of the company, so to get the particular name reserved, so that the company can adopt, right? So for that, to get the company registered, you should have membership. Minimum members required. If it is a public company, you should have 7 members. If it is private company, at least 2 members you should have. So it is been said by section 12. So they say that to form a public company, at least 7 persons should be there, and to frame a private company there should be at least 2 persons, and these persons will subscribe their name in the memorandum of association, and they are going to comply with the requirements of the Companies Act. So whatever the Companies Act says respective to the register of company, so to get the company registered, so all those things they are going to agree with, and they are going to subscribe their name in the memorandum of association. So it should be carefully noted that the purpose for which the company is going to incorporate should be lawful. So it should not be forbidden by the law, or we can say it should not be against the interest of public policy. So whenever you are going to start a business, so your purpose of starting business or starting a company should be lawful. So in promotion stage, in incorporation stage, to get your company incorporated or for the purpose of incorporation, what the promoter is going to do? So the promoter should apply for the registrar for registration along with the documents. So there are some following documents. So in incorporation stage, with the promoter should file it with the registrar. The first is your memorandum of association. So as I have told you, memorandum of association is the first document prepared by the promoter of the company. So that document he is going to file it with the registrar, and that document will have the information regarding the name of company, aims and objectives, address of the register office, capital structures, nature of liability, etc. So it should be properly printed and duly stamped and signed by at least 2 persons in case of private company and at least 7 persons in case of public company. So how many members we are going to have to start the company or frame the company? It may be public company or private company. If it is a private company, you should have 2 members. If it is a public company, you should have 7 members. So all those 7 members should sign in this memorandum of association. The next is your articles of association. So articles of association is also the document. So this document will have the rules and regulations. So regarding what? The internal management of the company. So it should be likewise memorandum also be pointed and duly stamped and signed by the subscribers of the memorandum. So with what membership you are going to start the company, so all those members who are going to subscribe the memorandum should also sign the articles of association. A public company limited by shares. So if the public company is going to, or if the public company limited by shares, so they can have table A. So they can have table A or they can adopt the table A, but all other companies must prepare their own articles of association. So except the public company limited by shares, so rest all companies should have articles of association. So your table A, what is this table A? Table A will also have the set of 99 rules. So it is also similar to your articles of association. So articles of association may have as many rules or your own rule, which is, or we can say which is similar, or we can say which is as per the Companies Act or as per the memorandum. But here table A is a set of 99 rules which can be adopted by the public company limited by shares. And the next is notice of address of registered company. So this is a form which is usually filed along with the memorandum and articles. It must be given to the registrar within 30 days of incorporation. So if it cannot be filed at the time of registration, so at the time of registration, if you are going to fail to file it, so you can, or it must be given to the registrar within 30 days of incorporation. The next is forms relating to the directors. So what are the forms relating to the directors? So one is the list of directors. List of directors means the list of person who have consent, who are going to send the consent or written consent to act as a directors of the company. So the next is the written consent of directors. So one is the list the name of the person. Okay, the written consent means a separate written consent duly signed by each director of the company. The next is undertaking by directors. Here undertaking by directors means an undertaking by the directors to purchase and pay for their qualification shares, as I told you earlier. So the qualification shares will be there. If you want to be the director of the company, you have to purchase the qualification share. So undertaking of director means an undertaking by the directors to purchase and pay for their qualification share. The next is statutory declaration. The statutory declaration is nothing but a statutory declaration that all the legal requirements as per the Companies Act and other formalities regarding the registration of the company has been agreed with. So it should be saying that it should be filed with the registrar. So such declaration must be signed by the following. So one is, it may be the advocate of the Supreme Court or High Court, attorney or the pleader entitled to appear before the High Court, chartered accountant practicing in India, so who is engaged in formation of company, or a person named in the articles of articles as a directors, managers or the secretary of the company. So what they are going to do, they are going to declare or sign such declaration. The next is certificate of incorporation. So before going to certificate of incorporation, so let me tell you something more about statutory declaration. So as I have told you, statutory declaration is the declaration saying that we are agreed with the Companies Act with regards to or with relating to your registration of company. So here in that statutory declaration, all the persons, the main persons are going to sign. So the registrar is going to examine that document. So we are going to sign it and we are going to file it, right? So that will be examined by the registrar. He may, however, accept the declaration as sufficient evidence of compliance with the act. So he may accept it as a declaration, so that everything is been agreed by those persons, and if he is satisfied that all the requirements of the act in respect of registration has been complied with, he will register the company and place its name in the register of the company. So what is going to do, when all these statutory declaration is been satisfied by the register of the company, so then he is going to place the name in the register of the company, and a certificate of incorporation will be issued by the registrar, and that will certify that the company has come into existence, right? The next is certificate of incorporation means, so this is the birth certificate of a company. Company comes into existence from the date mentioned in the certificate of incorporation, and the date conclusively, or the date that appearing in the certificate will be conclusive even though it is wrong. So it is said that even though the mentioned date in certificate of incorporation is wrong, so that will be the final. And you cannot change it. So this is called as certificate of incorporation. Thank you.